Hi, I'm Lynsey Harrison and I'm a partner and head of the Contentious Private Client team here at Clarion Solicitors. And today I'm going to be joined by Jeremy Bristow, who's one of our fantastic solicitors in the team. And today we're going to be discussing the appointment of independent administrators in the context of administering estates.
Mm-hmm. That's right. Yeah.
Hello.
Hello.
And so, Jeremy, firstly, why would someone seek out the appointment of an independent administrator?
Yes, so unfortunately, as we know, during the course of the administration of an estate, relationships between the parties can break down. So that might be the personal representatives have fallen out, or the personal representatives and the beneficiaries have fallen out. And in those situations, that can cause real problems for the estate administration because there's lots of delays and even impasses that last for years and years. So in those situations, you might want to consider the appointment of an independent administrator so that the estate administration can continue while any underlying issues are being resolved separately.
So it's wherever there's an argument and it's sort of clearing out all those people, bringing someone in independent just to sort of get on with things. And
exactly. Take the heat out of the situation.
Absolutely.
Yeah.
And so how is an independent administrator appointed?
So it's appointed by the court, it's a court order, so that might be where all the parties are in agreement and applications made, or it might be one party wants the independent administrator appointed and they will make an application, or in certain situations the independent administrator may well apply to be appointed themselves, and that's usually where all the personal representatives are in agreement and the beneficiaries. And that would be an application to the court. It can be made pre or post grant, whether there's a will or there isn't a will. And as you might imagine, or as you know rather, at Clarion we only tend to get involved when there's a need for a professional independent administrator such as a solicitor, or as is more often the case, a trust corporation connected to a law firm. And of course you'll know this very well because you have been administrator of many estates in your personal capacity, and you're also director of the trust corporation at Clarion.
Absolutely. Okay, so what does an independent administrator actually do?
Yes, so great. So the main role of the independent administrator is to act impartially and sort of bring in some clarity, I suppose, into the estate administration. And that's in situations where there's often quite emotionally charged disputes going on in the background. So they're trying to sort of take that heat out, again, like I said earlier, take the heat out of the situation and try and just focus on what's required to administer the estate. That's obviously their main role, is to administer the estate in accordance with the terms of the will, if there is a will, and in accordance with the law, and sort of balancing the commercial and practical factors. So trying to be sensible in how they go about that role. The administrator might even look at identifying the issues in disputes, and once that's done, trying to encourage the parties to try and settle those issues. That might be through ADR, such as mediation and things like that. And we've certainly had situations where we've used things like Scotch schedules to set out all of the issues that are in dispute between the parties. And in one particular case I'm thinking of, that Scotch schedule was used at a mediation, which ended up successfully settling, and that was quite useful for the parties to see it all laid out, so they can focus their minds effectively.
And just to touch on the phrase that you used a couple of times there, impartiality, what does it mean for an independent administrator to be impartial?
Yes, so quite important for the independent administrator to treat everyone evenly and fairly, not favour one beneficiary over another. It's obviously easier said than done.
Very much so.
So on sort of in that respect, it's not, in sort of practical terms, it's not for the administrator to necessarily go against one party and start issuing proceedings and things. It's to try and treat everyone fairly, but appreciate obviously in certain situations that is the only option, and it's not unheard of for an administrator to issue a claim, and so that sort of claim might be, for example, Part 64 directions to try and help unblock any blockages, essentially.
But we try really hard not to get involved where it's the beneficiaries are at war with each other, don't we? That's which is a common misconception, I think, of independent administrators. And as you say, absolutely rightly, we have to be even-handed between everybody, and try and stay back and be impartial.
Exactly right. That's
Absolutely.
it.
And you mentioned earlier that an independent administrator is generally a professional person, such as a solicitor. What sort of information would be needed for a solicitor to decide whether or not to take up the appointment as an independent administrator?
Yeah, so we're very open and we'll speak to anyone, any of the relevant parties when we get inquiries at Clarion. And really the main purpose of what we're asking, what information we need, is to try and identify the practical consequences of an independent administrator being appointed. So we ask for quite a lot of information just to try and help us identify whether that's appropriate or not. So we'll ask questions about the liquidity of the estate, so not just its value on paper, but what the actual sort of what the cash in the bank situation is and things like that. Details of properties, where there may be someone in occupation, because that could be quite a tricky issue. Any interpretation or construction issues in relation to the will, if there is a will. We also ask for the details of historic and current tax liabilities, and IHT in particular can be quite tricky, making sure there's funds to cover that or it's being paid already. We'll look at things like ongoing costs and expenses related to the estate, so that might be in connection with properties. And we'll also ask for information about historic and current and potentially future liabilities and administration costs or testamentary expenses, and again how those are going to be funded, because it's a lot to sort of think about, and having that commitment from the independent administrator. So in many cases we can assist. But even if we can't assist, we'll let the parties know why we can't assist, and even I've had cases where that's in itself has been helpful for the solicitor in coming to us asking whether we can act, is to help them identify what sort of issues are, what issues we have, and then they can take that away and hopefully use that to try and settle matters.
Yeah, absolutely. Well, thank you very much, Jeremy. That's really helpful. And as you said, if you've got any issues or you'd like to think about appointing us as independent administrators, do get in touch. We're always happy to have a chat and figure out if we can help. So thanks very much for joining me.
Great, thank you very much.
Thank you.
Thank you.